Can your lordship kindly to mention one motion matter upon notice? This is the motion is pending since April. Recently, 2 days before, one recovery notice was
Give it. So please mention the grounds so that at the time of listing.
Very short.
But if you don't mention the ground at the time of checking the list, will not be able to make out which was mentioned for what.
Write down and
The listed motion, your lordship.
For inclusion,
For inclusion. For inclusion, my lord. My lord, this is for upgradation, my lord. My lord, this matter is running in right. Item number 173. But my lord, they have initiated recovery proceedings against me.
write the grounds of urgency and give.
My lord, may I have your lordship's kind leave to mention item number 405 in your lordship's list today? My lord, I am mentioning this. My lord, this is an application where my lord I have brought on record a letter by which my lord the show cause notice, which is the subject matter of challenge in the writ petition, has been closed. So my lord, I am praying, my lord, your lordship will look into the application, take note of that letter, and my lord dispose of the writ petition. My lord.
405.
Yes, my lord, it is an application.
405 is a contempt application.
No, my lord, it is appearing under the heading application only.
Oh.
Yes, my lord, in this application, my lord, I am bringing on record the letter by which the show cause notice issued against me has been closed. So, my lord, on the basis of that letter, if your lordship can dispose of the writ petition by recording it. Very well. My lord, I shall put in the ground of why I am mentioning it also when I hand over the...
Yes.
My lord, I am mentioning on notice.
Inform your other side.
My lord, I am mentioning on notice, my lord. My lord, I will.
May I be permitted, my lord?
এটা দিয়ে দেবেন একটা মঙ্গলবার বা এরকম দেখে একটা আপডেটেশন করে দিন আর্জেন্ট মোশন হেডিং এই দিয়ে
I'm so grateful.
May I be permitted? My lord, what happened? The Kolkata Municipal Corporation has formulated a recruitment regulation 5 months back. Immediately, we preferred a writ application indicating that, my lord, the illegality of that particular regulation. It was taken up for hearing by the Honorable Justice Kaushik Chandra and directed Kolkata Municipal Corporation to file their affidavit in opposition in a stipulated period of time. No affidavit, and it was directed to be listed as under hearing, my lord. No affidavit. Now, my lord, the KMC is going to appoint, my lord, the assistant engineer in terms of that, my lord, illegal recruitment regulation. I have no other alternative but to mention this matter. I have enclosed herewith, my lord, the notification they have published through MSC. At the same time, the order passed by the Honorable Justice Chandra. My lord, as a result of which, my lord, if this particular appointment process is initiated and appointment is made, my lord, multiplicity of suits and proceedings, we are not dormant. Immediately we take action and, my lord, file writ application. Lordship, kindly see, my lord, kindly see the last page of the order of the Honorable Justice Kaushik Chandra. And here is a specific direction to file their affidavit within 2 weeks, and thereafter, my lord, the matter to be appeared under the heading hearing. My lord, till today, no interim order. As a result of which, because of at that point of time interim order, my lord, we are praying for court was kind enough the matter to be listed under the hearing and affidavit to be exchanged. No, that was not recorded. Virtually, yes, my lord. Lordship, yes, my lord. This is implied. My lord, the thing is this, lordship was kind enough. So, my lord, if this appointment is, my lord, started and all these things are taken place, my writ petition will be infractuous. So that is why a date is required to be, my lord, fixed. But I am repeating my submission, keeping in the mind my position, my lord. Number of persons are there. My lord, as per our feelings, my lord, it is urgent. Lordship may, my lord, refuse it. Because my lord, on 8 onwards, some person will come and submit their application before the authority. As far as my submission is concerned, that is faulty. No, 8, my lord, 8 is Tuesday from Monday. I have effected service, my lord. But I know, my lord, the lordship predicament I know, but at the same time, I have no other alternative but to approach. My lord, may I take it back, my lord?
My lords,
Deeply obliged.
my lords, may I have my lords kind leave to mention?
But let me allow, my lord, to try in other places, my lord, because...
May I have my lords kind leave to mention Item
up.
392, my lord. My lord, we had filed the writ petition on Monday. My lord, there are some incurable defects. My lord, I'm seeking liberty to file afresh, my lord. Yes, my lord. Yes, my lords. Very well. Yes, ma'am. Great.
But I am the petitioner in this. Well, we have affidavit of service is there, your lordship's record, but yesterday after mentioning also you have given hand service. Hand service of.
Well, this is, if I'm not wrong, well, this is a,
This matter.
my lord, I'm appearing for the,
Oh, he is appearing for this state.
Yes, Mr. Chatterjee, why are you online? Chakraborty.
chop, but I have some personal difficulty today. I couldn't come to court.
But here, but without giving arbitrary reason, my goods were detained by the SGST authority, which are perishable in nature, without following the due procedure of law. Your lordships knows better than me. But when an owner has come forward and claiming their goods, which has been detained, the Lord, it has to be in terms of 129 1A. Your lordships knows better than me. But the authority has imposed 129 1B, where the owner is not come forward. And if your lordship see the order, but they have dealt with all my objections and then pass an order that I am not claiming the goods. And that is the reason, my lord, we have assailed this order before your lordship. But kindly see 129 and 129A and B once.
129.
Yes. Detention, seizure and release of goods and convenience in transit. Notwithstanding anything contained in this act, where any person transport any good or stores any good while they are on transit in contravention of the provision of the act or the rule made thereunder, all such goods and conveyance used as means of transport for carrying such goods and documents relating to such goods and conveyance shall be liable to detention on seizure, and after detention on seizure shall be released. But this is very important. But kindly see A. On payment of penalty equal to 200% of the tax payable of such goods. In case of exempted good, but my goods are not exempted good, but these are erica nuts, but these are forest products, so it is not exempted. B, but this is applicable, but kindly see, then whichever is less, where the owner of the goods come forward for the payment of such penalty. Milord, got it? Now see B, Milord, on payment of penalty equal to 50% of the value of the goods or 200% of the tax payable on such goods, whichever is higher, and in case of exempted good on payment of amount of so and so, it is not so and so, where the owner of the goods does not come forward for payment of such penalty. Milord, kindly mark these two provisions. Then, Milord, I shall place the case before your lordship. Now, Milord, kindly see. First, your lordship, kindly turn to page 24 of my application.
Page 24.
Page 24 of my application. Milord, this is the tax invoice. Milord, kindly see, I am Damru Enterprise. I am the consignor, who is the petitioner before your lordship. Your lordship will find my GSTN number is mentioned here. Milord, got page 24, annex chapter 2.
Yes.
Milord, the GSTN number is there, and the consignee, the goods was going from Assam to Delhi. Milord, got it, Milord. Now this Navakar Tradex, its ground floor, it is in Delhi. So these goods were Delhi, but right hand side your lordship will find there is a e-way bill number. Your lordship knows better than us. But in this act, but for transportation of goods, Milord, the e-way bill has to be there. Right hand side, the e-way bill number is also there. Milord, got it? Right hand side, Damru Enterprise, right hand side top. Invoice number,
Yes.
yes. Now your lordship kindly see, dated 10th of November 2025. Milord, got it? Right hand side?
Yes.
Then your lordship will find the destination Delhi, that just bottom, the motor vehicle number is also given. Then your lordship will find the description of goods. Milord, kindly marked it, Milord, dried erica nuts, and kindly mention the, Milord, the quantity also, 495 bags. Then your lordship will find the quantity and amount total is 43,65,900. And I have paid tax of in terms of the act, because dry dairy cannot have a 5% tax. Now we have paid the tax also 2,18,295. Now the next page, my lord, kindly come. Your lordship will find the EUA bill. Your lordship knows these are all generated bills. So EUA bill also your lordship will find in page 25. The EUA bill number is there, and your lordship will find right hand side valid up to. Got it? 20th November. It was, my lord, it was loaded on 10th of November, and this bill is valid till 20th of November as per the EUA bill. Now your lordship also find that the same quality has been as well as described here, dry Erica nut, 34 so and so kg, and the rupees also same. Now, but they have detained our goods. Your lordship will find that order, the show cause order in page 28. But on two reasons they have detained our goods. As per them, but the goods, the tax invoice, it was shown the goods was loaded in Assam, but the case of the authorities, the goods was loaded in Jalpaiguri. This is number one. But they have never disputed that the quality and quantity of the goods and the tax payable on the goods also. It is admitted that for dairy canard, 5% tax has to be levied. But the goods are there, my lord, your lordship will find they are assessing this on basis of a radio frequency identification. They are saying on 10th, your truck was in Jalpaiguri, where weight of the truck was taken by us. Now, and after one day on 11th, with the material, the same place the truck was again, my lord, the weight was taken, and that is the reason they are saying the goods were loaded in Jalpaiguri, not in Assam. This is their only case. They are not disputing relating to the tax payable amount regarding the quality and quantity of the goods. This is their case. And my lord, I am not going into the facts of the case because my lord, these are disputed issues. My lord, I can also revert back. But the law says, my lord, they have detected this on basis of a radio frequency identification. There is our High Court judgment. It says the radio identification frequency is not the conclusive proof, and that on that basis it cannot be detained. There is a judgment of Mailasis Bhattacharya. If your lordships want, I can. But still, I am not. For the timing, I am not mentioning it. And it is, and my lord, it is their case that I was taking the same route, not diverted any route. Para, my lord, the 17, 18, 21, 22, and 24 is relevant. For the timing, your lordship keep this. Let me, my lord, place the case first, then I shall, my lord, place the judgment. Para 18 onwards, his lordship has laid down the law regarding the radio frequency identification.
Yes.
Yes. Now, my lord, to go to Delhi, there is only one route there. Your lordship knows, from Assam to Delhi, it has to go through Jalpaiguri. There is no other route. So, their case, I have loaded the goods in Jalpaiguri. I have not loaded the goods in Assam. This is their only case. Now, see my show cause, the reply to the show cause. Your lordship will find in page 32. Page C2, annexure P4.
C2.
Yes. Your lordship will find the nature of the goods and documents were in order. My lord, got it? That valid tax invoice, EUA bill, transport document, weightmanship, everything we have given. Now your lordship will find that weightment at origin was not possible due to security issues, because we said, but it's a forest product. From farmers we obtain it in a remote places. So where it was loaded, it is not possible to weight that material because of the security reason. There is a chance of theft and other reasons, your lordship knows. So that is the reason we said that where we have procured this good, we could not weight it because of the security reasons. That we have given there. Now your lordship will find the next page. Your lordship will find no induction of EVA tax, because admittedly tax is 5% on these goods, admittedly as per the statute. And then your lordship will find the next page, page 35. After dealing with my representation and the show cause, they have said that I am not the owner of the goods. First, kindly see, show cause was issued to me. They themselves, kindly see page first. Page 28. My lord, kindly see page 28 once again. To whom they are issuing this? They are issuing it to the driver. My lord, got it? Now, who was carrying the goods, and then, my lord, page 31, how they have calculated the goods. Page 31.
Yes.
My lord, they have in show cause notice, page 31 and 32, my lord, 129.1 and 129.1b both have been stated. My lord, kindly see now they have the, my lord, the value, the quantity is same. They have increased the value. It was 43 lakhs. Now they are saying it's 79 lakhs 65,500. Well, got it. They have calculated in terms of 169, 129, 1A and 129, 1Bs. Although the 129, 1B is not applicable. My
Because
case,
owner had not come forward.
my lord, why the owner has not come forward. Now, your lordship, my reply, we have given our reply page in 32. Just now, your lordship has seen. We have given the detailed reply. Now, kindly see the order passed by them in page 35. But they have dealt with my all the points. But kindly see few pages. I shall. But page first, page 39. Last part. In view of the above, his submission is not accepted. In para 2, in his reply, he has made submission differentiate when genuine particular reason. You mentioned that weighment was not conducted the place of origin as stated in the invoice. In this regard, the following factual submission is made. So they have dealt with my submissions also. Your lordship will find in page 40, they have dealt with my enter submission. Then says the reason provided by him, non-weighment of the origin are not creditable and no supporting document have been produced. Although I have produced the original tax invoice, original e-way bill, the approx distance between the purported place to dispatch of the goods, Assam, Dhubri, Assam, and the place of weighment Dhubri is 143 kilometers. Their case was, if your lordship can remember, 10th, the vehicle tier weight was taken in Jalpaiguri because it was going from Bihar. The tier weight was there on 10th. We have loaded the material on 10th. But as per them, the total distance is 143 kilometers, 4 hours or 5 hours. So we have loaded the goods in Assam. Then while we are coming back in the morning, we have again taken the gross weight on 11th morning in Jalpaiguri. On the same route we are going. It's not a different route. Now they are saying that 10th you have taken the tier weight and 11th you have taken the gross weight. So there is a violation. So we can assume that the goods were not loaded in Assam. Only on assumption.
No, but where was the weighbridge?
Weighbridge in Jalpaiguri.
Was in Jalpaiguri.
Yes, but because your lordship
because weighment was done at Jalpaiguri, therefore.
Yes, that is the reason they are saying
that it was not loaded at Jalpaiguri.
And we have
Assam,
given,
but at Jalpaiguri.
We have given the reason also. You see, there is because of it's a forest product. We collect it from the farmers in the remote places in Assam. Then we load it, and there is no blood. It is not possible to do the weight because that measurement cannot be done in that way. There, where we have loaded it. But as a bona fide the businessman, what we have done, because your lordship knows, during the transit also there is a possibility of stolen of goods. So that is the reason we have done it there, where we have taken our tier weight, the same places. This is our regular practice. Now they are saying you have loaded it in Assam, but they are not disputing regarding quality and quantity of the goods and the tax which has been levied. Now, I have given my reply. He has dealt with all my reply, and your lordship will find. Kindly see, he has dealt it. Then page 41. In paragraph 3, in his reply, he has made the following submission: no intention to evade of tax. The following facts proves there are absolutely no intention to evade of tax. So these are my reply which he has dealt with. Then 42, your lordship will find middle. Hence, his submission is not accepted. Got it. Then ultimately in page 43,
yes.
Second para, in view of the above facts, it is also clear the actual supply of the goods is not Damru Enterprise. So and so, GSTN number so and so, it is not the owner of the goods. And also no other owner could come forward. I have no opinion, but a penalty in clause B of 1 on 129. But he has dealt with my the entire show cause. Now he has come to a conclusion, I am not the owner. But the authentic document is tax invoice as well as the EUA bill. They have never disputed that. And your lordships knows these are the statutory document. It is not their case, these are forged documents. And our High Court's judgment, my Justice Lord Shivanganam, sitting in a division bench, held the EUA bill and tax channel are only below the reliable documents. Lord, kindly see this. Para 3. We have perused the 3 notices. We found there is a split of details as regard to the nature of the goods which are carried by the broad classification has been mentioned in the invoice. It is not disputed the quality of the weight of the goods which are carried in vehicle has been found to be correct by the department on physical verification. Then there is no discrepancy. In our case also, my lord, the same. Apart from that, the gross description of the product as contained in the invoice also does not show any change of product carried in the vehicle. Same in our case. The inspecting authority appears to have been made a roving inquiry and went beyond the description of the goods and described 3 invoices are recorded information regarding seized pipeline so and so were not mentioned in the invoice. Therefore, the question invoking 129 of the Act does not arise in the facts and circumstances of the case. That apart, the authority has not able to pinpointly show that the appellant has an intention to evade the payment of tax. This is more so HSN tag. In our case, HSN tax is not Ericanat. Classification of goods are identical and there is no disruptor of the department. Therefore, it is not the case where the procedure under 129 of this Act could have been drawn, could have been detained and penalty could have been imposed. It may be different matter in during the process of adjudication of the authority has taken up these cases and regard to the classification of. Well, got it. But this is my case. But in terms of their calculation, if you actually see their calculation, but kindly see page 43. Although they have the valuation, it was 43 lakhs. The valuation was of the goods, but they have given 79 lakhs 69,000. Well, got it. Tax invoice shows 43 lakhs, but without any reason, they have given 79 lakhs 69,000. This is number 1, and my tax will be calculated in terms of 129 1A, the penalty. 200% of the tax, 5% tax I have already paid. But that is in tax invoice, your lordship will find 2,18,000 into 2, 200% means into 2. So it will be, my lord, almost 4.5 lakhs. My humble submission before your lordship is this, my lord, I am ready to give a bond and let my good be released and let me permit to do business.
Yes, Mr. Chakraborty.
My lord, first of all, my lord, this is an appealable order. This is an appealable order. Well, this is an appealable order, and none of the judgments, I'm sure, man, it is related to arrogance. I am not being privy to those judgments, but I'm not. Possibly I had appeared, but I do not know the citation, so I cannot say anything on this. But the question today is, this entire movement has been questioned. Entire movement of the goods, and this is a specific findings of the authorities. My lord, that is on fact. My lord, would kindly come to page 42, the last paragraph. 42, the last paragraph.
Yes.
The RFID toll data and the weighmanship shows that the goods were loaded in the conveyance for some place in West Bengal, lying between so and so and not from the declared place of dispatch in Assam. It shows that the purported consignor, Damru Enterprise so and so, is not the actual consignor of the instant goods. And the actual consignor is some undisclosed suppliers who have and use the tax invoice and so details of Damru Enterprise. But this is a specific finding. This is a specific finding, my lord, of the issues raised. My lord, a person carrying 34,000 kg. My lord, it was not 1 or 2 kg, 34,000 kg.
What is the law regarding payment? Where is the payment supposed to be done? How does the statute guide payment?
My lord, it has to be from the place of origin. My lord, how do one create issue a e-way bill? My lord, would kindly just before that, my lord, law, my lord, I'll just kindly see the date of the e-way bill.
Date of e-way bill.
Yes. E-way bill, yes, my lord, 25.
Page 25.
generated date 10th November 2025.
10th November 2020.
2025. If it was weighed in West Bengal, how it could start from Assam? The date is very important. What is the date when which you are coming to know of the weight of the vehicle, weight of the goods? How do you ascertain that fact? These are all statutory documents, e-way bills. These are all statutory documents. How do you ascertain that fact? If as on that date, if it is not the weight is not taken, my lord. How do you ascertain? How do you start the journey? My lord, someone says, yes, I have taken the goods from Assam, but due to security reason, I go to another state, Jalpaiguri, and take the weighment.
So
Then
for every e-way bill to be generated, there it has to be preceded by a weighing.
My lord, how do I then quantify the tax component? My lord, tax has to be ascertained. So, my lord, this has to be
There's a
weighed.
point there, Mr. Mojumdar. The e-way bill shows the quantity.
Yes.
If it was not weighed prior to the generation of the e-way bill,
Yes.
then in that case, this quantity ought not to have been mentioned in the e-way bill, couldn't have come.
No.
My lord, just 1 second, my lord, they cannot travel without a way bill.
But they are talking about the
cannot travel.
quantity of the vehicle along with the goods. We have weighed the goods. Your lordships knows that in local market, there is the weight can be measured in local market, but along with the vehicle, it is not possible. That the infrastructure is not there.
E-way bill is not required to show the
No, vehicle number is not required. No, my lord, weight of the vehicle is not required.
Yes, Mr. Chakravarti.
My lord, the question, my lord, kindly appreciate. There cannot be once if, my lord, today we are dealing with a 34,000 kg of Arakanats. If 1 or 2 kg is sold outside the scope, we do not know, my lord, how to ascertain the exact weight. My lord, ultimately, someone in the midst of the journey, they sell out the things.
E-way bill, will only contain the weight of the material that is being carried by the vehicle, which is what the expression quantity is denoting.
My lord, with deepest respect, my lord, kindly come to page 30, the previous page, 24.
Page 24.
Yes, please. My lord, has it said anywhere in this document invoice that this entire exercise is starting from West Bengal or the weighment is taking?
I couldn't get you.
Where is the, my lord, my lord, there has to be some contemporaneous document to support the case of the petitioner. My lord, today, my learned friend is taking a case of weighmanship. I have done it in a different place due to security. My lord, this cannot be a case of in isolation. There has to be someone is selling the goods and someone is purchasing the goods. But someone must know what they are purchasing or what they are
how does the
selling.
court come to believe this, that in Assam there is no other weighing bridge and you have to come to Bengal only to get it weighed?
No, but in local market, when we have procured these goods, your lordship will kindly see the dried and
after that, for the purpose of weighment, why do you have to come all the way down to Jalpaiguri?
Because it's on the route.
In Assam,
on the route.
In Assam,
only one route is there. Only one route.
In Assam, from
Dhupguri, that is the nearest place.
The place from where you started,
yes,
until Jalpaiguri, there is no other weighing bridge.
No, that is the route we go.
On that route, there is no way bridge.
This is the common practice, this is the common practice. And this is not the first case. Earlier also we have given GST to the GST authorities. Your lordship will kindly see page 54 once. They have never raised these issues. This is our regular business. And these are forest products. It is not their case that I have aviated the tax. The tax is also same. Page 54. Quantity is also same. There is it is not their case even that I have they given the lesser quantity there.
And why are you not going before the appellate authority? This is an appellate.
Now the law is very clear. When the order is arbitrary in nature, division bench of our High Court on a similar issue, your lordship kindly see this judgment. In where this court, where the Honorable High Court can invoke 226 for the order, although there is a the alternative remedy. Para 13, kindly see. It is in respect of the GST matter only. Article 226 of the Constitution of India confers very wide power of the High Court to issue writ, but this power is discretionary of the High Court but refuse to exercise the detention if the satisfied and aggrieved person has adequate and suitable remedy elsewhere. It is a rule of discretion and a rule of compulsion of rule of law. Even though there may be an alternative remedy, yet
That
the
is
High
settled, that is settled, Mr.
Yes,
President.
but these are the criteria.
But in the facts of this case, where allegations as grave as this, that you may have because of this 140, because this also I mean surpasses comprehension of court, that from for a stretch of 143 kilometers there will be no way bridge on which a person can rely. Then in that case, all the vehicles which are carrying these kinds of material from Assam will have to come and get themselves weighed at. So that is why, because this is the sheet anchor of the case of the revenue authority.
Yes.
And this is something which needs to be thrashed out for anybody to come to a particular conclusion.
Yes.
Now, the writ court will not have the wherewithal
Yes.
to enter into this arena.
Yes.
This has to be decided by a fact-finding authority.
Yes.
Then in that case, without you going to the appeal.
No, how they have calculated. Kindly see, my case, admittedly, they have dealt with all my issues. They are not disputing the tax invoice. They are not disputing. Well, I could have understand they are disputing the tax invoice. It is coming out from their portal only. And the UA bill. That is the reason the division bench judgment I have given it before your lordship.
That is division bench judgment was after the appellate court's order. I have noticed that.
No.
There also it was the appellate court's order which was challenged, appellate authority's order. In Justice Hiranand Bhattacharya's judgment also, it is the appellate authority's order.
But the core issue,
in none of the cases at the adjudication
this case,
stage,
this division bench judgment, which now?
No, this is not in the facts of this.
No, this is the facts of this case.
Facts of the case are something which are definitely going to have a bearing. Here, the facts of the case are a little clumsy, because
I could have preferred an appeal if they have imposed the penalty in terms of 129(1)(a). I could have filed an appeal.
129(1)(a) they are doubting because they are doubting your ownership. They are doubting your ownership. Again, everything comes to the Weybridge thing.
No, on that basis, it cannot be done, Milord. Let them show one judgment that I have not weighted the entire along with the material and the truck. So, Milord, I am not the owner. Let them show one judgment on one authority on that.
No, it's not
on the contrary.
It's not about the ownership of the truck. It's about the ownership of the material. They are doubting it, saying that since you have weighed it at a particular place which is 143 kilometers away from the place where it ought to have been weighed, therefore it raises a suspicion that you may not be the owner.
But on what basis? On what basis they are doing? They are doing it on the basis of the radio frequency identification device. This is not a conclusive proof. Our High Court has said you cannot rely on that. It relating to the movement of the vehicle. You cannot say where the goods were loaded.
No, not only that. They are clubbing two things. It's not only on the RFID. It is also the weighment.
Yes.
Because weighment is something which they are using in support of their RFID conclusion. They say that from the RFID, it appears that the vehicle was at this place, and at several places in a given stretch.
Yes.
And from the weighment bridge, the timing of the weighment bridge matches with that of the RFID data. That is what I read from the order.
How they have calculated? The car was admittedly it's a BR.
If you see, I was going through the order just now.
Yes.
If you see the order, they have dealt with that paragraph. If you see,
But my humble submission till that day, they dispute the tax invoice as well as the UA bill. They cannot raise any question regarding the ownership of the goods. And I am coming forward. I am ready to deposit the penalty in terms of 129(1)(a).
Page 40.
Page 40. my lord. That I have seen, my lord.
Page 40, last 3 paragraphs.
Yes.
This does not appear to be very unreasonable. For the writ court to intervene, it has to be something which no reasonable person will
No,
conclude.
my lord, kindly see. It is also seen from the parking slip, the TR08 of the conveyance or measured on 10/11/2025 at 9:27 a.m.
Yes.
But kindly remember this. This truck was going from Bihar. It's a Bihar registration. So go to Assam. He has to cross Jalpaiguri because there is only one route. But kindly visualize the this thing. Admittedly, it's a Bihar registration car. The vehicle.
Where is that?
Yes, in
averment
tax.
the-
In tax. The tax invoice, your lordship will find
Yes.
that.
Show me that.
And it is their admitted case also. Page 24.
Page 24. Yes.
Yes, now see the motor vehicle number. Now, my lord, kindly see the show cause which they have given. It is in page 28. To whom they have given the vehicle number.
Page 20.
28.
Yes.
They are show cause. Kindly to whom they have given the show cause. The vehicle number the same. Well, these are factual issues, my lord.
That is why I'm saying, because these are factual issues.
Well, ownership is not factual issue. Ownership, my lord, I have the valid tax invoice. I have the UA bill.
Ownership is important for the purpose of determination of the penalty.
But the ownership, I am coming forward saying that these are my goods. You have dealt with all my blood, the show cause, the reply which I have given. Now you are saying I'm not the owner of the goods. Then you have to say this UA bill and this blood, the tax invoice are fake. That is not their case till today. But it matches that they have given the show cause to the driver. So it matches that we are the owners of the good. Very well. But let me pay a bond, let my material be released, and let them impose the adequate penalty in terms of 129(1)(a). I can prefer an appeal against that regarding this issue which your lordship is raising now. I am not escaping from, but if the appellate court feels that it will come under 120 and 1 to be only, then I'll do that. These are perishable in nature, my lord. That is the reason I have come up before your lordship.
By way of interim measure, before preferring appeal,
Yes.
Mr. Chakraborty, you can release the goods on their putting in the bonds.
My lord, we can sell out the goods and we'll keep the price of the goods.
What is
We'll
saying?
say we'll keep an auction of the goods. We'll conduct
You-
auction.
Mr. Chakraborty, if he fails in the appeal,
Yes.
then in that case you will be entitled to.
My lord, with deepest respect, my experience, this two matters and one matters I had personally appeared, we did not find this Araconat suppliers, my lord, it was not traceable thereafter.
Oh.
My lord, ultimately, my lord, we can auction these goods, and whatever the price, my lord, ultimately he'll be selling these goods. We can conduct an auction, and we'll keep the
shelf life?
price.
What is the shelf life of this areca nuts?
My lord, these are perishable in nature. Your lordship
Perishable means how much? It must have some shelf life. How much?
that I have to ascertain. That I don't know.
Because then I will direct you to prefer appeal and I will direct him to decide the appeal immediately. Within 3 days, 4 days, whatever it is, 5 days, 1 week. It can't be perishable because these are issues which must be dealt with by the appellate authority at
No, my lord,
First
appellate authority, my lord,
I would have intervened immediately if I would have found a grave jurisdictional error. You can't say that the authority did not have jurisdiction. There may be some procedural irregularity, there may be not.
My case
It
is
is
this.
not-
My lord, they cannot go away from the UA bill and tax invoices. My lord, they have to say these are false and fabricated. Then only they can come to a conclusion these goods are not mine. They are saying that this tax invoice and this UA bill is mine. But kindly consider this aspect. They have taken tax on that 5%, which are actually levied on the dried areca nut. Let me pay in terms of 129(1)(a). But I am ready to pay that. But let me go before the appropriate authority. In the interim measure, your lordship can release these goods for me. This will hamper my business also. At end of the day, your lordship will find, my lord, the article 19(1)(g) says right to carry on business, my lord.
Yes, but it has to be in accordance with
Uh,
law.
law.
Well, what is in accordance with law? My lord, in accordance with law, EOA bill and tax invoices. And
That
they
may
are
not suffice, Mr.
Lord,
Majumdar,
these
merely
are-
because I have this, it will not be presumed
Well, I
that whatever
understand. Lord, I am agree with you, Lord.
that is right,
Lord,
that you
I-
have that, but those documents you have, therefore everybody has it, so there will be no proceeding under GST.
No, I am not
That
saying
can't
I'm,
be-
Lord, I
that
am not.
can't be the sheet
Lord,
and
kindly see, Lord, I am not escaping from the proceeding. Lord, kindly consider that aspect also. I am not escaping. I will give a bond. I will face the appellate authority. Lord, let them calculate whether it will come under 120.
As an interim measure, it can happen, Mr.
Yes.
Majumdar, Mr. Chakraborty.
My lord, this
Let
would,
the appellate authority
my
decide
lord,
it.
with deepest respect, this would mean my lord is taking a stand that this comes under the 129(1)(a), where the owner has come.
Taking a
My lord,
stand. I'll clarify that,
Ah.
that it is just for the purpose of interim measure.
my
You, he will be entitled to,
lord, why he is shying away from complying with 129(b) one way and ask the authorities to
it is his case that
pay
he is
the
not-
money?
not falling under 129B because he has claimed the ownership.
Yes.
He has claimed the
My lord,
ownership. He has all
my
the
lord,
documents.
the entire case is, my lord, on stands on the footing. This transaction is a fraudulent transaction.
Where
This
is that?
EAA bills is not issued in the name. My lord, I have not interfered. My learned senior friend, my learned friend should not interfere. My lord, kindly come to the improbability of the situation. 42, kindly see. But there are observations to that effect. This entire case, the moment my learned senior friend says the authorities have dealt with his case,
Very
it
well,
means
but-
it's a.
but-
But kindly see 142, just how it is improbable. Kindly see the second paragraph in between. The distance. 42, my lord. Distance of 266 kilometers between Guwahati, Assam and so cannot be traveled in 36 minutes. Which is the difference of times
What is
between.
your answer to this? Because these are things.
This is
which-
a wrong
Well, these are
statement.
all factual disputes.
Well, right
My
now,
learned friend today do
Well,
not.
right
do
now,
not-
your lordship has said, well, at page 40, your lordship has only marked us. But kindly see second para, your lordship has only showed me.
No, this
Well-
was for the purpose of weighing. Now, these are in respect of two e-way bills which you have.
Yes.
You don't have one e-way bill. You have two e-way bills. That is what they are referring to.
Which one, my lord?
Page 42.
Yes, ma'am. There are two. This is on record also.
Yes.
So one e-way bill is generated at this Sundari Ghapa,
Hmm.
Kamrup.
Hmm.
Another one is at Dhubri,
Yes.
Guwahati.
Yes.
Now the distance between the two is 266 kilometers. The
Which one, my
time-
lord?
Dhubri, Guwahati and Sundari Ghapa, Kamrup.
My lord, these are all factual issues, my lord. That is the.
Very well, but then the conclusion, if the conclusion.
But then I have to take
apparently-
instruction regarding this also. Your lordship can give me one day
Because-
time. Or at 2 p.m. I shall take instruction from the
2
owner.
PM,
No,
I
2
have-
p.m. not.
2 PM it won't be possible.
But kindly,
Another
I
matter
don't know what
is-
is his problem. My lord, we
No,
have
no, this is an issue, Mr.
Yes,
Majumdar.
my lord,
When
I
I
shall
pass
address
an
you.
order, I cannot just ignore whatever.
No,
the
I shall
authority has said.
address you.
Kindly don't take it at 2 p.m. your lordship.
But-
There will be difficulty because even I am not carrying brief,
2
Mr.
PM, there is a matter fixed. I cannot take at 2 PM.
It will be
People from
difficult.
outside.
Or my lord, at 12:30 I can come.
No,
my
my lord, today not possible, my lord. Today not possible. My lord, if it is a perishable good, let them go before the authorities.
Authorities under MOPI, they can very well.
They
There is a
can
procedure.
always.
From Monday onwards, you have Jalpaiguri bench also.
No.
Yes.
Oh,
He doesn't
okay.
know. Well, everything he has, my lord, he doesn't know.
Very good.
Jalpaiguri is sitting on 15.
My lord, knowledge-wise, my learned senior friend may have better knowledge.
Heard Mr. Majumdar, learned senior advocate appearing for the petitioner, and Mr. Chakraborty, learned advocate appearing for the respondent WBGST authorities, full stop, paragraph. The writ petitioner assails an order dated November 21, 2025, passed by the Deputy Joint Commissioner of Revenue, Sales Tax, Jalpaiguri Circle, thereby directing the petitioner to this order is also on your driver,
Which one?
Anuj Kumar.
Yes, I only the driver because they have found him bloody possessing all these documents.
directing direct petitioner টা কেটে দিন, directing payment of না imposing penalty, দেখুন imposing penalty in terms of section 129 within bracket 1 within bracket small b of the WBGST Act, 2017 stroke CGST Act 2017. Full stop, paragraph. Mr. Mojumdar, the senior advocate appearing for the petitioner submits that the order imposing penalty is now suffers from gross errors. Full stop. It is submitted that at best the respondent SGST authorities could have invoked section 121 within bracket 1 within bracket A of the said Act of 2017 and not section 129 within bracket 1 within bracket B of the said Act. Full stop, paragraph. Mr. Chakraborty, learned advocate appearing for the respondent state authorities, however, submits that the authorities have rightly passed the order and that the writ petition may not be entertained in as much as the petitioner has an equally efficacious alternative remedy before the appellate authority under section 107 of the said Act of 2017. Full stop. Mr. Mojumdar submits that the case at hand is a fit case for the writ court to intervene in as much as the respondent SGST authorities have acted only on the basis of RFID data, comma, which is impermissible. Full stop. On the Achana, full stop. List this matter for further consideration on. Yes, Mr. Mojumdar, tell me.
But Monday, your lordship can skip it. Tuesday, your lordship can put this matter.
On December 9,
Or 10th, let it be on 10th.
10th, on December 10, 2025. 10th December.
Let
Mr.
it be on 9th, my lord. Let it be on 9th. But because perishable in nature, I
December
cannot.
9, 2025. Take full instructions.
Yes, I shall
Okay,
take
लिखे
full
दिन, Mr. Mojumdar, seek some time to take further instructions to make further arguments. List তারপরে list this matter.
I'm grateful, man. And my lord, I tendered apology for yesterday. I could not reach for any of the matters yesterday. I tendered apology, my lord.
No, I should apologize for not having
No,
the
no.
list in order.
No, my lord. It is not your lordship's fault. We should have been there.
Sincerely apologize for that, your lordship.
List was not in order.
It collapsed suddenly. We were just running our way.
And my lord has segregated us in such a manner from that court to this court, my lord. It takes some time. I'm grateful, man.
Date কত যেন আছে? Yes.
The first I am paying before your lordship unconditional apology, my lord. But I was not happy at that day. But I have, in pursuance to my lord direction, my lord, I have sent and they have refused to accept those, and some of them accepted. My lord, the matter is very short. Your lordship knows, my lord, regarding the I am the contractual laborer, but my payment was made by the master roll. But all on a sudden, the officer.
But Mr. Giri, nobody is appearing today.
Yes,
Why don't you serve the office of the government pleader?
Yes, my lord, Mr. Susimita Chatterjee appearing. I have personally talked with her. But your lordship, then next Friday.
Next Friday
Top.
it will appear. লিখে নিন।
But to be mentioned as to be mentioned. That will
No, no, it won't appear as to be mentioned, it appear as motion.
very well.
Not
As per previous order, state has to give the CM report lordship.
What should I am saying for not? I am saying for not.
yes, just
Page 12, R6, the report lordship.
page 12.
Yes, lordship. Page 12, R6, annexure R6. As the private respondents are not paying lordship,
Yes, madam.
a letter has given to the superintendent of police to take the legal action by the district magistrate of Calcutta. Request for legal action for non-compliance of the order dated 28/12/22 passed by the district magistrate Calcutta.
Mr. Nadishwar was appearing for this for private.
This has given to the superintendent of police to take the legal action.
It is some high people lodge, right?
Yeah, what was your matter?
Matters related to the accident happened due to the negligence or activities of the private responder 11 and 12. Electrification oil. My husband died, for which there
Yes.
is objection.
Who is appearing for
For
WBCDC?
WBCDCL, I'm appearing, my lord, led by Mr. Srijan Naik. My lord, several occasions we appeared, and it is a admitted fact that petitioner did not make party. Sorry, the private respondent made another writ petition, and they didn't make the petitioner as a party. So on the last order, my lord, it reflects the fact that already WBSCDCL and the private respondent appeared, and it was decided by the DM that the private respondent will give the compensation along with another cable operator authority.
Yes. Yes, sir. You were supposed to make payment, isn't it?
Got notice of fact, Lordship, Mr. Nadishwar was appearing for this matter.
Who is appearing?
Mr. Nadishwar was.
I'm unable to get you.
Niladri Shakur Ghosh, sir.
Niladri Shakur Ghosh. When will he come?
He is facing high fever, Lordship. I beg for not to take. I bring him for not to take. High fever, high Lordship. We appears in Lordship.
But kindly give the direction to the private respondent that they should make the payment lordship.
Let him come. a report.
That matter, my lord, I have served again, my lord. And my lord,
Yes, my lord,
first
I
bank
pay for the respond number 2.
there is a 94 notice, my lord.
Yes.
Yes, the numbers.
$408. Yes.
This is the notice, my lord, which the bank was served with by data number. Yes. For the convenience of your lordship, the.
Yes, it's a section 94 notice.
Yes, my lord. And the bank was asked to give information in respect of these 5 accounts, my lord, in which the disputed account is also one of the account, and was also directed to mark a debit freeze on this accounts, my lord.
So this police officer under section 94 could not have directed to debit freeze.
And my lord, that police officer, my lord, we have served 4 times, my lord. My lord, 106 is the, my lord, the appropriate section to, my lord, debit freeze, the BNSS.
BNSS?
Yes, my lord, I have. May I, my lord, just a minute, my lord, I will, my lord. And this is the 94 I have marked. On the 106 probably.
Yes. Yes, Mr. Chakravarti.
Mr. Chakravarti is for the, my lord, the CGST.
I was appearing from the CGST authority. Man, from the very first day I have submitted before your lordship that the answering respondent is located beyond the jurisdiction of this honorable court.
That doesn't matter. If the cause
No,
of
no.
action has, arisen here, the writ petition is maintainable.
Correct, man. I am not on that.
That point I am not taking. If you have any other
Man,
point,
I am not on that, man. Kindly allow me 30 seconds time, man. 30 seconds.
You have all the world's time,
My
but,
lord, 226.
but don't-
My lord, 226(2) provides that part of cause of action arises, the jurisdiction can be invoked. My lord, there are certain judicial pronouncements which says, even in the fiscal statute, in the central excise, in the income tax act, it is said that even if the part of cause of action has arisen within the jurisdiction of this honorable court, most importantly, when the jurisdictional appellate authority is within the eastern zone, then also when the answering respondent is, or the adjudicating authority or the investigating authority is located beyond the jurisdiction, and when the writ petition cannot be decided without the answer of that answering respondent, this matter should go before that honorable
show me that judgment which you are saying that.
my
this
lord,
has
my
been
lord,
said.
my lord, today I am little bit
Mr. Chakravarti, last
My
time also you were online, today also you are online. Don't take that as an excuse. Then
No,
you
no, I'm not.
present.
My lord, I'm not taking it. My lord, no, I am regularly appearing physically. My lord, for a few days it happens that I could not.
But almost on all the days in this matter, you have been online.
No, only 2 days, last day and today.
Malad,
They-
Last day and today were the days when
Malad,
we
contrary
were.
to that, I have a judgment of Nawal Kishore. Nawal Kishore says, Malad, under section 20C of the
Show
civil
me that
procedure.
judgment. When can you show? Then again, it will not be
My
taken up.
lord, I can give you a lordship of Bombay High Court judgment reported in 2019, 5 SCC 149.
If I don't have a copy, how can I just?
Malad, may I have a copy of Nawal Kishore? I can, Malad.
Yes, Nawal Kishore is known to me.
Malad, Nawal Kishore, Malad, where the Malad cause of action hits, Malad, your lordship, Malad. That High Court having the jurisdiction. That
When
clarifies
will
where.
you be here, Mr. Chakravarti? When will you be here? Since your point requires to be answered, I will answer the point and deliver a judgment because his account is also frozen.
Yes. No, his account is frozen. My lord, he is in
So
difficulty.
that needs to be taken care of.
My lord, my only prayer is that I am not the answering respondent. My submission, your lordship can record.
Very well, but since you want to rely on a judgment, I will not shy out from dealing with that.
No, I know. I am not saying that, my lord. Is
So
not
please
saying.
give me that so that I can answer it and proceed then.
May I kindly, will it be your lordship pleasure to keep the matter on next Tuesday?
Tuesday, we mentioned, Malad, I am suffering, Malad. I am suffering, Malad, since long, Malad.
Because today we are on Friday, my lord. If your lordship takes it on next Tuesday,
Next Friday, what will happen on next Friday? Friday you will be here 12th.
12th is 12 minute, may I take 1 minute, 10 minutes.
Please take. Because in the meantime, the entire schedule, four more days, you will come to Friday.
I know, Malad. And may I rely upon that Nawal Kishore, Malad, before your lordship, Malad. But I have a judgment of Malad, not judgment, the order of Malad Justice month on the Malad, the same point. Where
Malad, Friday.
Karnataka police.
12th, I am here.
Please be here on 12th with your
Yes.
2019
Absolutely. Malad, I can remember.
I am not accused of not dealing with the judgment.
Malad, I have satisfied your lordship on the point of Malad jurisdiction. But I have Malad.
In one matter, I had the occasion, personally, I appeared before the then Honorable Division Bench, presided over by Honorable Justice Indira Banerjee. The same point happened. I will try to find out the judgment.
Miss Ojha, learned advocate, appears for ICICI Bank. अच्छा एकदम ऊपर लिखून heard Mr. Ghosh, learned advocate appearing for the petitioner. Full stop. Miss Ojha, learned advocate appearing for ICICI Bank, hands up to court. A copy of the letter dated January 6, 2025, issued to the branch manager, ICICI Bank, by the officer in charge, Itanagar Police Station, thereby, within inverted commas, directing, inverted comma close, the branch manager to, within inverted commas, debit freeze, inverted comma close, the petitioner's account, full stop. It is noticed that the said notice is under section 94 of the BNSS, 2024 or 2023, full stop. Mr. Chakravarti, learned advocate, appearing for the petitioner. Chakravarti, or is it Chakravarti? appearing for the respondent, CGST authorities. Seek some time to place certain judgments before this court, full stop. List this matter once again on December 12th, 2025. 12th December.
Expecting Malad,
You please come with this also, that under section 94 there cannot be any debit freeze.
yes, madam.
Because the section is clear. But if I have authorities, we can deal with it.
Well, deeply obliged.
Mr.
And
Chakraborty,
and
what was the citation? I will read that.
My lord, I will provide a list to Monday before your lordship, along
Very
with
good.
a copy to Mr. Ghosh.
I'm
Very
grateful.
Deeply obliged.
আচ্ছা ওখানে একটা ওই লিখে দেবেন none appears for Itanagar police authorities.
But I have the affidavit of service of the last day.
আর affidavit of service টা service through email
No, speed post.
served.
Served.
Send an email also of this order again, so that
But they will not. If
Ah,
they
but
want
very
to,
well.
Malad, they-
My senior is engaged in courtroom number 38, so I am paying for short passover.
passing it over. Ask him to come because every time it can't go. What has happened here? What is this matter actually? Oh, that SEBI matter.
Yes.
Any. लिखे none appears. None appears on behalf of the petitioner.
Lordship, I am appearing for the petitioner in item number 410, Lordship. Mr.
Yes.
Learned Counsel, Mr. Pronit Bag is appearing in this matter, Lordship. Due to some personal difficulty, he is not in court today. I am praying for not today.
Not today will not do then. The fine matter every time. Last time also nobody appeared. Likhenin, an adjournment is prayed for on behalf of the petitioner. Full stop. List this matter once again on
Lordship, not on December 12th. December 12th, I have some difficulty. Lordship, a week after that.
in the monthly list of January
Much.
2026.
Lordship.
Next.
My lord, I am for the petitioner.
My lord, I am for union.
Yes, yes. Pursuant to lordship direction, my lord, I have served, my lord, the copies of the writ petition upon all the state authorities, ESI. My lord, affidavit service is ready. After a few minutes, I shall, my lord, because from morning I am here. I could not contact with my clerk. I will, my lord, affirm and I submit. My lord, and one gentleman has, state medical officer has refused. Others, my lord, they have received. Now the issue is, my lord, we are opted to be the brought under the ESI with certain benefits. But
You
nothing.
bring your affidavit of service, I am passing it over. Then I shall take up. Pass over করে রাখুন, affidavit of service এলে নেবে. Next.
Then, my lord, it will be after half an hour and coming back. Yes, yes. I'm grateful, my lord. Because it would be affirmed and coming back. Yes, yes.
Who is appearing for the petitioner? None appears for the petitioner. Full stop. No accommodation.
For 13, my lord, I am for the petitioner, my lord. My lord, pursuant to your lordship's direction, I will serve the authority. Serve them twice, my lord. My lord, that is, well, the Calcutta Telephone District Cooperative Limited, my lord, they have been served, my lord, twice. Once, my lord, the copy was served, another, the next occasion, my lord, the notice was served that the matter would be fixed today. My lord, the dispute, my lord, arises. Yes, my lord, kindly seize, my lord, the point, my lord, that I have to satisfy your lordship, my lord, whether the original policy bond was lying with me and whether, my lord, that policy bond was, my lord, at all submitted before the Life Insurance Corporation. Clear the loan, my lord. For that, my lord, specifically, my lord, they were, my lord, directed to be served. Since, my lord, the my lord, kindly consider Union Bank, that's a different certificate altogether, my lord. Different certificate altogether. My lord, my lord, I have, my lord, specifically, my lord, taken instruction on this. My lord, the husband of the petitioner died, my lord, sometime back, my lord, absolutely a layman, my lord, this petitioner. Two things, my lord, I can, my lord, satisfy your lordship. That, my lord, the original policy bond was lying with me, and, my lord, that I have, my lord, submitted before the authority. Since, my lord, if the original, the system is, my lord, in this kind of cases, my lord, where the original policy bond is, my lord, given as a mortgage for obtaining a loan. If the origin, my lord, until unless the loan is cleared, my lord, the policy bond would, my lord, lie before the LIC. In this case, my lord, kindly sees, kindly, my lord, takes up page 13 once, and, my lord, page 14 once, and, my lord, then page 13. Page 14 and, my lord, page 13. 14 once, 1-4. Page 14, my lord, kindly sees what are the documents that, my lord, this is addressed to the branch manager, city branch of the Life Insurance Corporation, my lord, kindly comes to the last line of the big paragraph, my lord. The first paragraph. The original policy bond number such and such to settle. So many, my lord, documents are attached. The last line is the original policy bond. And, my lord, kindly takes up page 13. Page 13 is the receipt dated, my lord, 21st of February 2023. Which has been issued to me from LIC, the Kolkata Metropolitan Division Office. Kindly seize, my lord, the receipt from Santosh Kumar Haldal, the policy bond. As such, my lord, the original policy bond, my lord, was lying with me, which has already been submitted, along with the other documents, my lord, to state claim. There is, my lord, no dispute as such with regards to, my lord, the nomination of the petitioner. The petitioner is the wife of the, my lord, my lord, the deceased person who availed a loan. My lord.
इससे मैनेज किया इससे हाउ वी मैनेज दैट engaged in court number 1. He is coming. I am paying, respectfully paying for short of person. Short person. Short person. Short person.
Mr. Ghosh engaged at courtroom number 9, Your Lordship. He will come.
To inform.
Or I appear for the petition.
I am appearing for state respondent.
But for last supplementary affidavit, I filed this. Right. Let's
Bow down.
yes, Lordships. The then learned advocate also not informed the petitioner, Lordships. I am stating all the fact. And liberty can be filed for
Order 9, Order 9, Rule 9, yes.
Order
Order 9, Order 9, Rule 9.
order 9.
না আছে মানে
এটা
19, sir.
order 9.
The part to a fresh shoot. If a shoot is dismissed under Order 9, dismissal of the 21st of the year, plaintiff cannot file a new lawsuit on the same subject matter. Part
Specify এটা সুপ্রিম কোর্টের লেটেস্ট জাজমেন্ট আছে যে ডিসিশন ফর ডিফল্ট প্রেসিডেন্ট পাওয়ার
না না সেটা তো ব্যান নেই there is no annexure.
that will perhaps in the limitation act restoration.
Yes. On the same.
Perhaps there is a judge, I don't know the context, but I find one judgment of our Supreme Court where Supreme Court said, my lord, the trace application which is dismissed for default on technical grounds or dismissed for default, press application would not be passed.
Here the delay.
That read, perhaps read.
Right. Minute, 5 minutes. There are 116. What's 16? 416. কত এটা? Whereas in this matter, I am for the petitioner. In compliance with the earlier direction of your lordship, my lord, I have complied with my lord and served upon all the respondents either by hand or either by hand on the learned advocate or by registered post to the respondent direct. But so far the respondent number 3, 6, and 7 are concerned, my lord. But the service of the writ petition as well as the order of your lordship could be contact, my lord, as because my lord, there is a postal endorsement, address is insufficient. And so far the number 11 is concerned, my lord, she left the address. Although my lord, she received the writ petition earlier. There is the affidavit of service. And my lord, I have filed an application for my lord, the addition of party in the state of West Bengal inadvertently, my lord. The state of West Bengal has not been made as party, my lord. And the state of West Bengal is my lord, the fit person, my lord, who can my lord, help me to my lord, by providing the address of the respondent number 3, 6, and 7. My lord, so far the number 3 is concerned, my lord. We my lord, serve the copy upon the respondent number 3 on the address, my lord, from which my lord, the communication was made to the petitioner. Yes. No, my lord, I have not served copy, my lord, because my lord, state of West Bengal has not yet been party yet, my lord. I have filed the application for making party. Yes.
Hello, I'm applying for respondent number 4. We want to file affidavit.
Petition, madam. ওদিকে যাব পার্টি অ্যাড করবো তো I beg to my lord, I beg to appeal. Let me submit. My lord, I am grateful, my lord, on last occasion, my lord has granted me some time because my lord, my relief has prayed for. My lord, it is right that in the writ petition I prayed for this certificate, death certificate, that my lord may remember that husband was missing from the ship. I took time to do some research work, my lord. I find, my lord, the act they referred, 1950 Merchant Shipping Act 1958, that act has been repealed now from 18th of August. 18th of August 2025, and in the act there is a provision 83. My lord, although it is not pleaded in my writ petition, I must be candid, my lord. To that aspect, my lord, I have made no prayer.
But still, my lord, I would argue, my lord, if my lord allows me, because the changed circumstances now, my lord, my lord, I understand, my lord. I understand. I yes. No, 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 not my lord. My lord, grant me such leave. Yes, my lord, kindly see 83. Yes, I because my lord, the act they referred, that act has been, my lord, repealed. My lord, see the first page of the act, my lord. It has
এই অ্যাক্টের কি নাম দাদা?
Shipping Act. 83, my lord. And the shipping master has now the role, and 83, my lord. Let me. 83, my lord, section where under the agreement with the seafarer any dispute rises between the master. Yes, my lord will find agreement is there, my lord, and my lord will find which data there. Yes. Consciously, my lord, when the shipping master wrote, my lord kindly takes up the report, my lord, filed by them. 107, my lord. Eta fresh city ta eta. This a better copy, my lord. My lord, my master was my husband's master was, my lord, copy to my lord got in the bottom, my lord. Third addressee was my lord, employer. Yes, my lord. And for reference and further necessary action under intimation to this office. So, my lord, CP master, knowing that because the agreement shows, my lord, I am the nominee for the social security. Page 23. 23 of the report. My lord, 23 of the report, I am the social nominee. And my lord, knowing that, my lord, consciously the shipping master wrote to my employer to intimate what further action you have taken while issuing the presumed death certificate. This much I have to show, my lord, and as per the section 83, and my lord, will find, my lord, this has been, my lord, done consciously by the legislature. My lord, this will help for these reasons, my lord. Admittedly, this ship is, my lord, is a ship of Hong Kong. This Hong Kong flag ship. 83, my lord, 2, subsection 2. Any dispute in an Indian seafarer, my husband was Indian, on a vessel registered in a state other than India, it is, my lord, Hong Kong flag ship, in the territorial waters of India. It was happened within the Indian territorial water. It was going from Bombay to Gujarat. New act. With the master or ship owners or his agent may be submitted to the shipping master. I would, my lord, pray that I may be granted liberty to approach these provisions. Yes, ma'am. Yes, certainly. But
indicate one thing.
এক minute. My lord, I would again, my lord, submit page 107. The shipping master wrote to my employer. Yes. Yes, dispute.
My lord, page number 18 of my report, my lord. We have enclosed the employment contract. Page number 23, my lord. Page number, my lord, 23. The missing person has declared the NOK, the next of kin, to be his father, and we have issued, as per law, the presumed death certificate to his father. Now, in the
I read the court and matter is API noted. Court number 1, Chief Justice. I am leaving the court from Mr. Juniorist.
now in the next column, the writ petitioner's name is mentioned as the, my lord, as the person who will, my lord, claim the compensation. But for this, my lord, we have issued the certificate to the NOK, not to the writ petitioner. And for my lord,
Next of kin.
Page 23. Page 23.
My lord, kindly see, my lord, page number 23. Next of kin, Vishnu Padopal.
With
Now
regards
kindly
to
take
the
over leave. No, my lord. I no, my lord. Next of kin details. I Shukantopal. That is the person who has yes. Vishnu Padopal. Now I'll kindly see page number 106. We have issued the notice to the NOK. Next of kin. We are not wrong, my lord, in our
No,
part.
they are not wrong. I am not saying you are wrong.
Now, my lord, in
But
so far
in
as the my lord, claim or compensation is concerned, my lord, if the petitioner so desires, can take steps. Yes, my
yes,
lord, that is it.
and page 23, my lord, will death compensation, my lord, page 23 it comes, my lord, once again. Death compensation has been nominated to the wife.
Yes, that is
100%. Social security.
that is not the
That
part of
is.
the instant read application.
No. Lord, even my lord, kindly have a look to this. Not only for this purpose.
Except the original side matter, may I mention, four, I think number 424. Has been taken up Friday week instead of next Friday.
My lord, 411 was made pass over, and my other side was supposed to come after half an hour.
Original side of 420.
My lord, 411. After original side, it will be taken.
But then 409 we adjourned to
So,
the next week.
In that case, my lord, it may be adjourned. Next Friday.
Your lordship will not be taken, will not take the appellate side. Okay, I'm good. Then why not we have to wait?
My lord, next item, appellate side, next item is my application, my lord. Appellate side, next item, 280.
Lord, I applied in this, my lord, there are two applications. My lord, GA number 1 and GA number 2. Now, my lord, GA number 1 was my application, my lord, for my lord interim protection.
My lord, in GA number 1, we were directed to file our affidavit in opposition. So we were trying to hand it over on the last date.
May I
kindly file it?
GA1.
GA1.
My lord, in GA1, my lord, kindly take up, my lord, the order dated 18th 18 June. My lord, this is a suit, my lord, for recovery of money. Now, my lord will kindly see the order dated 18 June. My lord, Justice Rao has recorded the contention. Now, my lord, an order of injunction, my lord, kindly comes to paragraph 9. Yes. Considering the above, this court finds that the plaintiffs have made out a prima facie case and the balance of convenience and inconvenience is in favor of the plaintiffs. This court also finds that at this stage, ad interim order is not granted, the plaintiff will suffer irreparable loss and injury. Accordingly, ad interim order in terms of prayer B. Now, my lord, kindly takes me lord prayer B. Prayer B. GA1. Kindly comes to me lord prayer B. Yes. Page 25. An order of injunction may be passed by directing the respondent and or each of them and or their main agents, servants, assigns and or representatives from withdrawing any sum from the said bank account number such and such maintained in the South Indian Bank corporate branch at such and such, keeping aside a sum of which 30 lakhs towards the claim of the petitioners. Now, this claim is admitted by them on documents. This was my application under order 12 rule 6. Now, kindly takes first page 53, 52 of this application. Mindful will find my letter of demand where I have set out a chart of the checks their letter. It's their letter. Sorry, addressed to me. Now, kindly see there are 5 checks which are appearing in the chart. Now, millet serial number 1 and serial number 2 millet was paid. 1 and 2 paid. Now, millet 3, 4 and 5 are the unpaid checks. Millet, absolutely, absolutely. Now, millet these checks, millet kindly turns the page. Millet, this is serial number millet 3 millet from the chart. Millet can relate the numbers. Millet, this was the check. Millet, which millet kindly comes to page 54. Millet dishonored. 53's memo is at page 54, generated by the bank. Two. Yes, dishonored. Yes. Now, millet this payment was made subsequently by bank in a NEFT. Now, millet 54. Millet kindly comes to page. Yes, kindly millet comes to page 65. Sorry, 65. Yes. Now, millet the check which millet was paid, serial number 2, millet that was in the dishonored. Millet I had to file 138. Then millet it was paid through NEFT. Serial number 2. Yes. Now, millet page 63. Before coming to page 60, kindly comes to page 63 once. This is the order passed by the bank shall court regarding the settlement. Now, millet remaining millet 3 checks. Kindly comes to page 65. Yes. Millet the memo of millet return memo, millet will find at page 67, generated by the bank. Return unpaid by the drawee bank, such and such. Now, millet kindly takes page 68, another 10 lakhs. Kindly turns the page 69. Check return memo. Now, millet 70, third check. Kindly turns the page 71. Return memo. Millet, these are the 3 checks which stood returned. Now, millet kindly comes to page 72. Yes. Millet, I had millet complied with 12A provision, section 12A. Millet, this section 12A millet was ultimately got millet a non-starter report because they did not appear. Page 83. Page 83. We orderটা কত 83 এটা না এটা now millet this is the report issued by the member secretary mediation center non-starter. Millet, I file a suit before your lordship's court. Now, millet, I have millet taken your lordships to the order, first order. Now, millet kindly sees millet they appeared on July 16. Kindly takes July 16 order. Now, millet kindly see millet they offered us millet that the matter can be settled, but millet naturally millet we have already seen them the process of settling before the mediation center. We have naturally millet that was didn't comments. Even if we have written, they gave us an offer which was not agreeable to us, which was much reduced sum. Now, millet kindly turns the page of the said order. In case failure of settlement, defendant is directed to file affidavit in opposition by disclosing the assets of the defendant within a period of 3 weeks. reply if any within a period of a week there. So my lord, it was not a simplicity reply, the opposition. My lord, it was affidavit to disclose their further assets, because naturally my lord, as an outsider, I will not be my lord, in a position to know their assets. Now my lord, and my lord, more so my lord, though my lord, there is an order passed by this honorable court by keeping apart or keeping aside a sum of 30 lakhs. My lord, it's unknown to us what is the sum lying there. Maybe it's in negative. We don't know. Well, this is for that reason Justice Rao felt it my lord fit that they should disclose and come up with an affidavit, not an opposition, come up with an affidavit disclosing their further assets. Now, my lord, this is an order of 16 July. Now, my lord, kindly comes to 18th August order. 18th August. This is the second direction. In view of the submission made by the defendant, time to file affidavit in opposition further extend for a week. Counsel of the plaintiff submit that intent was such and such and such. So, my lord, it again got extended. No opposition. Now, my lord, kindly takes my lord, 10th November. 10th November, before Justice Roy, they didn't even pray for the extension. Kindly see 10th November order. It was not even prayed for. Now, my lord, as on date, we stand that, my lord, there has been a non-compliance of my lord's court's order since July 2025. Nearly 6 months, my lord, will be crossing, my lord, 6 months on December 18.
My lord, my affidavit is there. My affidavit, I've brought the affidavit with me. The affidavit also discloses my assets, but the defendant is a public company. Whatever assets are owned by the company has to be reflected in the balance sheet and has also to be uploaded on the website of the registrar of companies. Everybody has access to it because it's a public company. So the plaintiff could have. I'm not saying that I'm not bound to disclose it because there is an order of court, and I have disclosed in my affidavit. If that could be permitted to be filed today, I will serve it right now. It was not, and there is a delay. I have no explanation for that. What I have disclosed in the affidavit, first is the assets, because that was a direction of the court. Second is around 26 lakhs was paid to the plaintiff, which we did not have knowledge of because the company is now with a new management. The old management has left. There has been a takeover. Within that takeover period, all these letters, 138 notices, checks, the dishonor of checks happened. In view of the new management, they did not have knowledge of what happened earlier. They did not have knowledge of whatever the debt the defendant owes to the plaintiff. Now they have found out, and I've annexed the bank statements as well with my affidavit in opposition, that I'll tell your lordships the date, from 8th April 2021 till 21st March 2022, payment of 26 lakhs odd have been made, which has not been furnished or pleaded in the plaint as well as the application. The transaction between the parties as per the plaint case happened in 2021, work orders and thereafter invoices in 2021. So whatever payment the defendant would make is towards those work orders or transactions which happened in 2021. Subsequent to 2021, whatever payments have been made by the defendant had to be adjusted, had to be credited, and the plaintiff should have accounted for those payments. The claim in the suit is a principal sum of rupees 30 lakhs. In the bank statements that I have disclosed in the affidavit in opposition, I have disclosed 26 lakhs payment have been made, and that has been completely suppressed. The ledger which has been produced along with the plaint and the application does not reflect these payments at all. Now, coming to the dishonor of I'm only praying that this affidavit may be taken on record and my learned friend can use a reply. Yes, I'm praying for extension. Yes, it was taken up earlier. On a few occasions, the matter was taken up.
And yes, we were there, and we initially tried to sort out the matter so that any settlement can be arrived at. Yes, that happened. Because, my lord, I'll tell my lord, initially 3 occasions, the matter was taken up on merits, where we submitted that this matter can be resolved if the parties negotiate. Thereafter, whenever the matter was taken up, it was only for extension of interim order, and it is our fault that I did not pray for extension of time to file affidavit in opposition. I have no explanation for that.
Only less than 10 seconds. Kindly comes to page 5, para 10 of the application. Para 10, yes. Yes, kindly see what I have written. The petitioner stated that as such a sum of 25 lakhs was paid by the respondent.
No, that refers to something else, which
Very
I'll
well.
show from the ledger.
Very well.
Which my lord,
Now,
if the senior friend presses for it.
Very well. First, my lord will have to inquire. What is the sum left in South Indian Bank?
Yes, that I have to indicate that bank account after the takeover process. That bank account does not exist anymore. Well, insofar as we have other bank accounts which are furnished in my affidavit of assets or the assets details. Well, the same order can be passed, injuncting me from dealing with without setting apart that sum. That is only fair.
Present bank account. He has to indicate from which date it is not there. He could have indicated this before the other.
Definitely, because I have
require an affidavit.
But I have indicated that the new management, they did not have knowledge of these deals at all. So they were trying to figure out what has happened. May I hand up the affidavit?
Less I know from NCLT doing matters. The very less I know from CLT ready, then NCLT ready. Comes up with all not by it's by an agreement. This is not a child's play going on.
No, but the bank account was closed, and thereafter, because of the new management, yes.
When will the yes?
No, that I'll take instruction, and it did not happen after the order was passed. Did not happen. It happened prior to the order was passed. Prior to the order being passed. Yes, Yes, it absolutely has to be disclosed. If your lordship takes paragraph 29 of my affidavit, page 11. আরেকটা কপি দেন এটা দিই তো page 11 paragraph 29. Page 11, if your lordship sees, I've given details of 3 current accounts. These are the accounts from where? And in paragraph 29 itself, I've pleaded that after the takeover process was concluded, the banking operations were shifted to these accounts, these 3 bank accounts. I've also pleaded that. But can you give me 1 minute?
June. First order is in June.
Right. Effectively from 24th, paragraph 15 at page 6. Yes, 24th January 2024. That is where the newly constituted board took over the company. And that is when the bank operations shifting that took place. Paragraph 11 are the bank accounts. Any one of these accounts, because
to disclose which account holds how much amount, I will find the data.
Well, that is there in the these have sufficient balance, because I have disclosed. I have disclosed my financial report, entire financial report.
They have to disclose which bank account holds how much. Today, my lord, heard that it is not closed.
I understand. Yes. The earlier order was ex parte order. We could not even intimate.
Inform the court.
Yes. Yes, absolutely. That's what is seen. But page 151, if your lordship takes of volume 2. But the first page 151 lordship is found. These are the any of the bank, all these bank accounts have sufficient. No. Inventory is this. Trade receivable is the.
Does not go, what this does not know what.
Very
what
well.
the
But
closing
lordship,
balance.
lordship gives me 7 days time. I'll disclose whatever balance is lying.
Very well.
I'll.
Till such time, let order be passed on these three accounts. Let him bring, then my lord will modify the order.
Well, insofar as his claim is concerned, whatever order was passed, except that, we are free to deal with
On
that.
these three accounts, whatever they are listed. And we'll have one more prayer, according that make action that July you are waiting till December. So that an order should be passed so that litigants should not take court light. They have been appearing on price, they have been appearing. Now, kindly impose some cost, not even to me, to any other. Any other. That first order.
কি বলবো
Objected to that.
But I'm carrying my affidavit in reply today. Well, there is no difficulty. Well, my time to file written statement was expiring during the vacation. In fact, we went before your lordship and sought for leave. Yes, well, lordship was taking. Well, lordship had granted me leave, but the only yes. So 9th October, yes. But those are always. But only thing is, well, by the time lordship granted us leave, no, lordship had granted me leave to file the written statement subject to the outcome of this application. Yes, that is the usual order. But by the time your lordship had granted me leave, that was already 5 p.m. So the department could not accept. The next day they accepted as on this. ঠিক আছে। Grateful.
Only one player. Some urgency.
HON'BLE.
Grateful.
That matter, my lord,
only-
kindly keep
only-
it on,
only
because I
one-
have affirmed the affidavit.
I'm not saying it, but I reserve my right to seek Miller's like Miller and I, if it is required. So it may not be taken that.
Yes, because of
Lord, 11th of June 2025, I appear for the High Court Administration. We were directed to file a report in the form of an affidavit. 11th of June 2025, we filed the affidavit, report in the form of an affidavit in the department. I believe, my lord, it has come up. No, item 2, na, 3 to.
Item 2, my lord,
Oh, I'm sorry, I mean item 3, my lord.
It's 3, item 3. My lord, this is the matter, your lordships, kindly see your lordship's last order passed by your lordship. Raised to a directed for. My lord, I am for the corporation lordship. My lord, regarding respondent prior to that, my lord, your lordships, kindly see your lordship's last order, page 1. Raised was directed for actually putting the 2 report in the form of affidavit, one by petition and another for both the report has already been come before your lordship. Lordship.
Lord, kindly direct the registry to tag it.
আমার কপি দিন
এক্সেপশন দিয়ে দিচ্ছিস
আচ্ছা
No, this is assigned.
assigned ও
দাঁড়া, আমাকে একটু
করো
বলতে
করো
দাও।
করো see what the honorable judge said now the jurisdiction says
ওটা না, আমারটা। Lord, has the report come?
anyway we are ready
Yes, yes, yes. Yes, yes. Next week, my lord.
next week
I'm given to understand Mr. JP Khaitan is on his way. He'll be reaching in a minute. Well, if I may, on the last occasion, my senior had submitted about, proposed to take a leave.
With the name.
Been served. I mean, with my lord's leave, and not on that alternative remedy, but there's one decision which my learned friend referred to in section 9C, the controversy regarding that not as at present. Before natural justice, I started, may I finish this quickly and then move on to natural justice. But this section 9C controversy, not the view which has been taken by the tribunal, if my lord is pleased to have it, volume 4, at page 582. 582. And this aspect did not fall for consideration by our court in the Indian Paints decision. So this decision came to be rendered later. But 582 is where it starts. This is that Essilor Luxottica. And they kindly take note page 596. Kindly note page 596, where the heading is not in the middle of the page, position prior to amendment made by Finance Act 2023. Now they have reproduced the provisions, and thereafter kindly take at page 602. Paragraph 52, 53, 54. In Saurashtra Chemicals, may I place it? The Supreme Court, after examining the provisions of the Customs Tariff Act, observed that the order of the designated authority is purely recommendatory and that an appeal lies to the tribunal against the determination, and that determination has to be made by the central government. In Tata Chemical, the Supreme Court noted that determination as contemplated under Rule 18 of the 1995 anti-dumping rules takes place when the central government issues a notification, and therefore an appeal would be maintainable before the tribunal against the said determination. The maintainability of an appeal under the unamended Section 9C of the Customs Tariff Act was examined at length by this bench in Aquatex, and it was held that the appeal would be maintainable against the decision of the central government contained in the office memorandum not to impose anti-dumping duty. The bench also examined whether the determination by the central government was legislative in character or quasi-judicial in nature, and after examining the relevant provisions of the Customs Tariff Act, the 1995 anti-dumping rules, and the decisions of the Supreme Court and the High Courts, observed that the function performed by the central government is quasi-judicial in nature. So this was the position prior to the number post-amendment is the heading at page 603. Kindly have page 607. Paragraph 67. Keeping this in mind, the amended provisions of Section 9C of the Customs Tariff Act would have to be examined. An appeal lies to this tribunal only against the determination or review, while under the unamended section an order could be filed, an appeal could be filed before this tribunal against the order of determination or review. The review talked of in section 9C of the Customs Tariff Act is a review contemplated under the first proviso to subsection 5 of section 9 of the Customs Tariff Act. Under subsection 5 of section 9 of the Customs Tariff Act, the anti-dumping duty imposed ceases to have effect on the expiry of 5 years from the date of such imposition. But the first proviso as it stood prior to the amendment made by the Finance Act 2023 stipulated that if the central government in a review was of the opinion that cessation of such duty is likely to lead to continuation or recurrence of dumping injury, it could extend the period of such imposition for a further period of 5 years. After the amendment, the words in a review have been deleted from the first proviso and substituted on a consideration of review. Thus, under the amended subsection 6 of section 9 of the Customs Tariff Act, the central government has only to ascertain the margin of dumping, and the power of determination of margin of dumping has been left to the designated authority. Likewise, the power of review is with the designated authority, and the central government can extend the period of imposition of anti-dumping duty for a further period of 5 years on a consideration of review. Under the amended section 9C of the Customs Tariff Act, an appeal lies to the tribunal against the determination or review, which powers as noticed above are exercised by the designated authority. Then note section page 608-71. The explanation added to section 9C of the Customs Tariff Act by the Finance Act 2023 has defined determination or review to mean determination or review done in such manner as may be specified in the 1995 anti-dumping rules. I will kindly take paragraph 75. The explanation that has been added to section 9C by the Finance Act 2023 provides that for the purpose of section 9C1, determination or review means the determination or review done in such manner as may be specified in the 1995 anti-dumping rules. Under the 1995 anti-dumping rules, the determination or review is done by the designated authority. It therefore clearly transpires that after the amendment made in sections 9A and 9C of the Customs Tariff Act by the Finance Act 2023, an appeal would lie to this tribunal against the determination or review, which as noticed above is undertaken by the designated authority. So no, that's their analysis of the provision. Then note, kindly take page 612. Paragraph 79. They refer to the Tata Chemical decision of the Honorable Supreme Court in the earlier paragraph. Then in 79, it is in the context of the unamended provisions of subsection 1 and subsection 6 of section 9 of the Customs Tariff Act that the aforesaid observations were made by the Supreme Court in Tata Chemicals. After the amendment made by section 134 of the Finance Act 2023, the determination or review is only by the designated authority, and it is against this determination or review that an appeal would lie to the tribunal under section 9C of the Customs Tariff Act. What therefore follows from the above discussion is that section 134 of the Finance Act 2023 has not come into force since the central government has not issued any notification as contemplated under section 12B to bring into force the said section. Consequently, the amendment to sections 9A and 9C of the Customs Tariff Act by section 134 of the Finance Act have not come into force. An appeal would therefore lie to this tribunal under section 9C of the Customs Tariff Act under the existing provisions of the Customs Tariff Act against the findings dated 29 September 2022 of the designated authority published in the Gazette and the consequential notification dated 27 December 2022 published in the Gazette imposing anti-dumping duty. The contention advanced by learned counsel for the appellant that even if a notification is contemplated under section 12B of the Finance Act 2023 is now issued to bring section 134 of the Finance Act into force, the tribunal would still continue to have jurisdiction to entertain an appeal against the notification issued by the central government imposing anti-dumping duty as it had before. To hear appeals under section 9C of the Customs Tariff Act cannot be accepted. So much the view taken was that those provisions have not yet been brought in force. The earlier provision enabled the appeal only after the notification was issued. Now, this matter traveled to the Honorable Delhi High Court, page 614, and kindly take note page 618, paragraph 11, and then the next page 12, 14, and 15. The effect of this cauldron would be the question as to whether the CSTAT would have jurisdiction to hear a challenge to the notification by the central government imposing anti-dumping duty or not. In the opinion of this court, the issue requires consideration as the interim order of the CSTAT holding that the said provision have not been notified could have unintended consequences. Section 9C of the Customs Tariff Act, pre and post amendment, does not leave any doubt that insofar as the determination of anti-dumping duty is concerned, the appeal could be heard by CSTAT. It is only in respect of an order of the government notifying, modifying, or not notifying anti-dumping duty that the dispute has arisen, owing to the amendment in the Finance Act 2023. The central government's notification dated 27 December 2022 in this case is the subject matter of this dispute. The appeals arising from the interim order are stated to be listed before CSTAT tomorrow. Considering the fact that CSTAT has ruled on whether amendments to the Finance Act itself has come into force or not, this court would like to examine the matter. In view of the above, there shall be a stay of the interim order dated so-and-so passed with CSTAT. However, CSTAT would be free to proceed with hearing of the appeals only insofar as they relate to findings of the designated authority. The pendency of these proceedings would not affect the final hearing of the appeals in respect of the final findings of the designated authority. Similarly, this is the position note. Appeal lies. The CSTAT says that it is only after the notification, because the amendments have not been notified. The court has been pleased to direct that as an interim measure, the CSTAT should proceed with the hearing of the appeals. So just not to the appeal is there. Whether I can go against the final findings at this stage, according to the tribunal's view, I cannot. According to the order of the Honorable Delhi High Court, they have said that in the interim, yes. So this is where it stands. But as I've submitted, it is not a bar. That place that decision of the Supreme Court. So this is just to complete the picture on the alternative remedy. Now the decision which my learned friend placed. No, that is not correct. Look, the judgment in Rekap Chen Jain, which my learned friend placed. Kindly have page 4 of that decision. Page 3 first, paragraph 7, where the exceptions are recognized, restated, if I can say, by the Honorable Supreme Court, where the writ jurisdiction can be imposed, violation of natural justice principles is noted in paragraph 7, in Roman 2. That is restated. And then the facts here, if my lord is pleased to have paragraphs 9 and 10 at page 4 and 5. While deciding whether to entertain a petition under Article 226, bearing in mind the precedents in the field, a writ court ought to additionally notice the forum designated by the statute for the litigant to approach. This is necessary because the alternative forum that is provided by the statute has to be one which can dispense speedy and efficacious relief. However, as in the present case, if the statutorily designated alternative forum happens to be High Court itself, whose jurisdiction under Article 226 is invoked, and not any ordinary statutory functionary tribunal, refusal to entertain the petition should be the rule and entertaining it an exception. So where that statutory appeal is before the High Court itself. So this decision states that position. Then paragraph 10, we may profitably refer in this context to the Constitution Bench decision in so-and-so. In so-and-so, this court had the occasion to lay down a principle of law which is salutary and not to be found in any other previous decision rendered by it. The principle plainly is that if a remedy is available to a party before the High Court in another jurisdiction, the writ jurisdiction should not normally be exercised on a petition under Article 226, for that would allow the machinery set up by the concerned statute to be bypassed. So this is all that this decision on the facts of this case, that is the decision of the court. So this is done now. Now, if I can move to the natural justice. I was placing. I have got a set for my for the learned counsel appearing for the respondents 1 and 2. Not for you. Not for you, sorry.
What's the papers?
Lord, I will request my learned friend Lord, to turn it Lord, after the hearing, Lord, because Lord, it's a commercial thing, Lord. I don't personally don't understand this confidentiality, but Lord, they're business people, Lord.
Not in a litigation matter. There cannot be any confidentiality litigation matter.
The
The judgment when it goes back pretty back in years, Malad. And it can be deducted, it can be a confidentiality before Malad, other benches, but not in a litigation before a court, Malad. Then it has to be shown to everyone.
Lord,
That is the law I'll place it also.
That is how Lord, it was conducted before the authority. I'm not deviating from that. So, Lord, Lord, I can do that. Lord, I will.
It's a question of
Lord, Lord, then my Lord will have to take my word for it, Lord, because that portion is redacted, Lord, and I don't really want that to happen because Lord, the record before the very, much, because not in my grounds, Lord, I have given a gist of it.
But may I say this much, sorry, sir. But I believe this is more or less going to the merits of the matter.
No, this is
We are
natural
at this-
justice. I'm on natural justice, sir. I'm on natural justice.
And
not on
natural justice, we have to. Yes.
Yes. Yes, ma'am, absolutely.
The facts and figures wouldn't matter.
Lordship. 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 But I'm
But
grateful.
before that, the territorial is there.
That
has
of course.
to be.
That of course. But,
Yes, yes.
so Lord, kindly then have Lord, kindly have Lord, volume 4, Lord, page. Yes, ma'am. Volume 4, Lord. I think everything would be in volume 4. But that page 467. But it starts kindly, I had drawn attention to it on the last occasion also, but page 493. Lordship. Well, this is the table of the 493, the bottom dumping margin, and the table note page 494 where the 40 to 50% is mentioned, the rest are all aesthetics. So this was the disclosure statement. It contained no criticism of anything that I had submitted. If this was to be treated as something to which I had to respond, it had no criticism of what I had submitted. It simply mentioned this. Now, kindly take note page 526. But the my lord. Yes, ma'am. Yes, but kindly see the headings if my lord is pleased to have the headings at page 490.
I make one submission. Kindly just doing it. Mr. Salve is online, but for some reason your lordship's voice cannot be heard, my lord. If your lordship kindly, if the mic is on, my lord.
It is on, but it gets off at times.
I'm so sorry, my lord.
So, my lord, kindly see, my lord, the heading of the different columns.
Yes.
Dumping margin table. So, my lord, the first is producer. Next is my lord, normal value. Now, my lord, if they have changed my normal value, I do not know from this what the normal value they have taken. The net export price, my lord, if they have tinkered with that, my lord, I do not know, my lord, what they have done. Dumping margin in dollars per metric ton, dumping margin percentage, dumping margin range. So, my lord, these are, they only fill up the last column. The rest are all, my lord, unknown. So, my lord, the normal value, if my lord is pleased, similar, I do not know, my lord, how they have, what is the figure they have taken. It is simply not the.
So the figures which have been redacted and which are now represented by 3 asterisks.
Gotcha.
The figures in the first row were supplied by you, which have now been
Originally supplied by me.
Yes.
Originally supplied by me from normal value I had given, net export price I had given, dumping margin what I had said is negative or minus. That was my calculation. And the dumping margin range was again negative. So if my lord is pleased to have page 20 of my writ petition.
Page 20. Yes.
So these are again index figures, not the actuals, taking 100 as the base. So cost of production, this of course is not mentioned here. Normal value, I had given 105. Export price I had given 124. These are as I submitted index. Dumping margin according to me was minus 19. Dumping margin percentage was less than 0. But they have come to 40 to 50%. So therefore my figures have been changed. Otherwise, they could not have come to 40 to 50. If according to my calculation, it is less than 0, because there is therefore no dumping at all. There's no difference between the normal value.
The method of calculation becomes important.
The method and the figures taken, because if a best judgment is done, as would appear, if that is the route taken, then the figures, something is being used, some material is being used to come to new figures. So unless I know, because those are my figures being changed. I'm not concerned with anyone else. These are my figures. It is my cost of production. It is my normal value. It is my the export price. So they are being changed. So if I do not know why it is being altered, or what is being substituted, what material is being taken into account to reject it or to alter it, then.
So at least in the copy which was supplied to you, your figures or the figures which have been taken to arrive at this conclusion of 40 to 50%
was not mentioned.
Should have been made known to you, so that you could have judged as to whether the ultimate conclusion reached by the authority is correct or not.
One is the mentioning the absolute figure also, but the other is not on what basis, by using what material or data are you coming to that figure. Because if it's something that I can understand just by looking at it, it's all right. But was it possible for me to figure out if they gave me the final figure as to how 100 became 141? Now, page 20, if my lord is again pleased to have.
Yes.
But they made that because they gave me the absolute figures. So the figure that they gave me told me that they made 100 into 141. I will come to that part. So they had made 141, but on what basis, by taking into what material this 141 was arrived at, I do not know. Now again 105 became 177. Now the foundation of it is the cost of production. From there they have traveled to the normal value, but there again, because the first is lacking, I do not know how the second has been arrived at. Export prices will remain the same. Now, because of cost and normal value, cost of production, normal value, I am
Yes.
now so this was not the situation. Now kindly see the letter which I wrote, not at page 526. This on the same day, 10th September 2025. This top portion is a forwarding mail. It is from my representative, the professional entity which is handling my matter, sent on 10th September to DGTR. My lord is found it. But 526.
Yes.
The top portion is just forwarding mail, recent forwarding mail. Then it is from Prashant Sharma at ELP, that is the form, to Rajiv Kumar Soni, JD12 DGTR. This is the government, and then copied to. So it is addressed to Mr. Soni, who's the Director of Foreign Trade. First paragraph mentions about the proceedings and the disclosure statement. Then kindly see, pursuant to the above, we request you to kindly share with us the confidential calculations of our clients for the following: the confidential dumping margin calculated, including normal value, export price and cost of production, and methodology to arrive at the same. Detailed calculation of cost of production in case of any changes made to the claim cost. Detailed calculation of landed value for each of our clients, including detailed workings if facts available standard have been applied for any export price landed value determination for any channel of sales to India. Please note that the provision of the above information is necessary to enable us to meaningfully assess the conclusions arrived at by the authority and to effectively provide its comments to the disclosure statement. This is also in line with the authority's obligation to uphold the principles of natural justice as a quasi-judicial body. We have been provided with only 7 working days to offer on comments on the disclosure statement.
Yes, great.
Lordship. Now, kindly thereafter take the page 529. Here.
$529.
Now, this is the reply received. And these are the figures are redacted. So my lord has seen that the figures are redacted, not the COP allowed. Normally they say producer, exporter, subject country, COP allowed. So this COP, cost of production, is one figure. That 141 that I referred to. This was whatever is the equivalent in dollars per metric ton. They just gave that. If my lord would like to have a glimpse at page 510, my lord will find that it was just one figure. That cost of production is a particular figure. And for the two companies, the petitioner in the first matter and the petitioner in the second matter. There's one more document that I need to show because the response is in 2 documents. Page.
This redaction at page 529 has been done by you.
Yes. So that the complete thing is there, but it just mentions an absolute figure. Now at page 561.
561.
Yes.
Didi, you flagged in 561. Thank you. 561, some figures are given again.
Yes, my lord. Now, my lord, this is also 10th September from my lord, the DGTR, and my lord, it is so my lord, landed price, net export price, normal value. So here again, what they gave one figure.
So
my lord,
normal value was one of the three components that was utilized in deriving the dumping margin.
Yes.
So one of the three is given.
Yes.
And this net price, net export price, and landed price.
This, you know, this is the price at which I'm exporting. So, you know, that is not in controversy as such.
And that is not,
Altered.
usable for the purpose of arriving at the dumping margin.
Look, it is used. So, look, it is normal value minus export value. So, if the difference is in the, look, if the normal value, that is my normal value, is higher than the export price, which means that I am dumping, I'm underselling, I'm selling at a lower than my my normal value should be. So much therefore normal value is, in order to arrive at the normal value, the cost of production becomes relevant. So at page 528, 529, they mentioned the cost of production, and at page 561 they mentioned the normal value. So they gave the absolute figures. Now after this note, I wrote to them again. Now I'm not kindly take page, but I have to take my note back to page 530.
530.
Yes, sir.
Yes.
Now kindly take note the paragraph 3.
Paragraph 3.
3 note.
Yes.
This is written to the Directorate of General of Trade Remedies. Lack of disclosure of methodology. At the outset, the exporters respectfully submit that they specifically requested disclosure of the following from the DGTR further to the issuance of the disclosure statement. The cost of production of the exporters and the methodology adopted to arrive at the same, the confidential dumping margin calculation, including the details of the normal value, export price, and adjustments with a link to the data filed by the exporters during the course of investigation, and the detailed calculation of landed value for each of the exporters, including workings in case the facts available standard had been applied for any export price or landed value determination for any channel of sales to India. In response, the DGTR has merely provided numerical figures for landed price, net export price, normal value, and cost of production, without disclosing the methodology, adjustments, detailed workings, or sources underlying these figures. So this is the thing, that they were given absolute figures, but not without disclosing the methodology or the materials. This was not the point made. And not the mere glance at those pages will show in the unredacted version that those are just absolute figures, and that was my complaint. Then with paragraph 5, the absence of such disclosure amounts to a clear violation of Rule 16 of the anti-dumping rules, which obliges the authority to disclose all essential facts before final findings are notified. The methodology applied in arriving at the above figures is unquestionably an essential fact, as it directly impacts the dumping margin. Moreover, as a quasi-judicial body, the authority is bound to uphold the principles of natural justice by withholding disclosure of the methodology and calculations relied upon. The exporters are being deprived of a fair and meaningful opportunity to comment. Then paragraph 7. The gravity of this non-disclosure is underscored by the fact that the figures recorded for the exporters' cost of production are wholly inconsistent with the verified records placed on record. So much that they're completely inconsistent with what I have submitted. But that I'm saying. Then not kindly see paragraph 9. Accordingly, there was no basis for deviation from such verified costs. Indeed, nowhere in the disclosure statement has the authority stated that the exporters' costs are unreliable, unverifiable, or otherwise unsuitable for reliance. Yes, the authority has disclosed cost figures that are grossly inflated compared to the verified data. So not verified data is my data, which they have verified. In my case is that they've verified my data. Then it is evident that the authority has applied undisclosed methodological changes or adjustments to the verified data. These changes have not even been disclosed, let alone justified. The result is an unwarranted inflation of cost particularly that cannot be reconciled with the exporter's verified books of account or with the authority's own practice in prior proceedings. Then wrote page 532. The exporters note that in the previous investigation concerned the same product and the same exporters, which the authority has referred to in the disclosure statement to support some of its determinations. The authority accepted the exporters' verified costs of production for the purpose of determining profitability of third country sales without any such inflationary adjustments. The exporters further submit that there has been no change whatsoever in their operations, accounting practices, or cost structure between the earlier investigation and the present one, warranting any change in the authority's position with regard to the exporter's costs. In particular, the feedstock supply agreements are identical to those that were considered in the last two anti-dumping investigations on imports of MEG from Kuwait. Relief requested 14I, immediately disclose the methodology, calculations, and sources applied in computing the exporter's cost of production and landed value. Then note opportunity of hearing and extension of time. Then note kindly see note the they did not give anything. So I had to go ahead because the time was not extended. So note page 533. Note
your comments.
My comments. And note, I had made this point also note right at the beginning as a preliminary objection. Note page 535. Note incomplete disclosure of essential facts. And so note note it is this note the same kind of note objection as I had already note when I requested. So they have only given us the numerical figures, and therefore note it is more or less on the same lines, but maybe a little expanded. But reference was made not to a decision of the Honorable Supreme Court in Reliance Industries. Not I shall place it because that judgment not required the authorities to disclose those workings. So I will be referring to that. And then not the entire criticism is then in summary in paragraph 18 at page 539. Accordingly, the continued non-disclosure of such workings is unsustainable in law and cannot be reconciled with the requirements of Rule 16 and Article 6.9 of the Anti-Dumping Agreement or the settled principles of natural justice. The disclosure statement in its present form therefore falls short of the statutory mandate and fails to satisfy the legal standard of disclosure under Rule 16. Then note the discussion note thereafter is on the calculation, but there they've referred to the legal. Kindly take page 540, paragraph 24.
540.
Yes. But 22 minutes.
22.
It is evident from the disclosure statement that the authority has not relied on the verified costs and allocations submitted by the exporters. The disclosed cost figures differ materially from those on record and therefore cannot be reconciled with the exporters' verified books of account or the allocations historically utilized and furnished during the investigation. This demonstrates that the authority has disregarded the verified costs without any stated reason. Then again, paragraph 24. Instead, the authority appears to have exercised unreasonable discretion to apply certain undisclosed adjustments or methodological changes to the verified data. And then the paragraph 25, page 541, such unexplained deviation is arbitrary. In fact, the Honorable Designated Authority followed the exact same methodology as was followed in the previous investigation in terms of cost and normal value determination. The margin of dumping would be negative. Then page 542, paragraph 33. But the lack of transparency in 34. Without prejudice to the above objections, the exporters provide their comments with disclosure statement below. So then they dealt with it as best as possible, but without really knowing as to what was it that they're really dealing with. So this was then one more letter was written on page 565. But this was to the to the government, the Ministry of Finance. And this 14th October, it is pointing out the executive summary of concern on page 566, my lord, please.
566.
Yes, ma'am. Paragraph 7 is violations of natural justice and deficient disclosure. So, my lord, I pointed it out what was happening, and my lord, so my lord, this my lord, actually this letter my lord, has gone my lord, after the final findings came out. Kindly see, my lord, the date is 14th October. So this was a representation made after my lord, the final findings, which are of September 27th, 23rd September 2025. So, my lord, this is stating, my lord, that what has been said for the first time in the final findings. My lord, there is some criticism regarding, my lord, my figures for the very first time, my lord, in the final findings, which, my lord, I was not asked to answer at an earlier stage. At the earlier stage, the only, my lord, absolute figures were given. But that's it. Now, my lord, so, my lord, in paragraph 8, what is mentioned is, despite these representations, only headline figures were provided at page 566. Despite these representations, only headline figures were provided. No workings, sources, or reconciliations were ever shared with the Equate Group. Also, crucial reasoning was introduced for the first time only at the stage of final findings after the exporter's opportunity to commence had closed. So, this was the representation made. Now, kindly have the final findings in volume 1.
Yes.
Page 123.
$123.
Yes.
Yes.
But paragraph 156 and 157. The participating exporters have claimed that their cost of production has been arbitrarily revised and that such revisions were not made in the previous investigation concerning the PUC's product under consideration. The authority notes that each investigation is carried out on the basis of specific facts, submissions made, and information provided, and substantiated with relevant supporting evidences during the course of investigation. The authority further notes that several interested parties have claimed that essential facts have not been disclosed. It is noted that all essential facts have been disclosed as per authority's consistent practice. This is all that they say. But my paragraphs have been dealt with in this sentence that we have disclosed everything. But the record will not show that apart from the absolute number, that they have not had to disclose anything else to me. Now, then page 124, paragraph note, this was placed by
yes, 159 and 160
yes,
were placed by Mr.
yes,
Salve.
Yes, no, 159 note is interesting. Note, the emphasis was on my not disclosing the feedstock agreement. So, note this paragraph, if I may just place this way. The authority has determined the cost of production based on the revised response submitted by Equate Group to the extent the same could be verified. It was noted that both Equate and TKOC purchased raw material, ethane, for production of captive input ethylene from their related party, Kuwait Petroleum Corporation. However, the same was not reported by them in Appendix 10 submitted in original response. Further, it was noted that there was significant difference in ethane purchase price reported by the two producers in Equate Group. Equate Group refused to provide copy of feedstock supply agreements with KPC to substantiate their claim to purchase price, mentioned that the said agreement contains very highly confidential and commercially extremely sensitive information and as such cannot be submitted on record. The authority notes that under Rule 7 of the AD rules, confidentiality of information cannot be claimed by the authority itself. On account of refusal of information, the authority has relied on best information available on record to compute the cost of production. So, Lord, this is, sorry, my Lord is rising just now.
Yes, because I have a division bench at 3.
Lordship.
You can continue for 5 more minutes.
Lordship. So, Lord, there are two things here. Lord, one is my not giving them the agreement. The other is they're proceeding to use best information available on record. So, the first thing apart, Lord, whether my non-disclosure allows them to also proceed on a basis of non-disclosure, because Lord, they are using something on the thing available on their record, Lord, which has not been put to me. So merely, Lord,
was this disclosure by you essential for the purpose of their calculation of that anti-dumping
yes,
margin?
Yes, Lord, I will show, Lord, from the record that, Lord, this agreement of mine, Lord, they had visited my plant in the earlier investigation. Lord, they had looked at this agreement. In this investigation, Lord, I requested that if you're going to the site, please have a look at it there, or we can show it to you online. I did not want to give a copy, Lord, that's a fact. But Lord, and it's on record, Lord, I show from the letter. You can please have a look at it online. It is the same agreement which was shown to you in the earlier investigation, and Lord, the price mechanism, the basis on which, Lord, that agreement fixed the price, Lord, that was explained in great detail, Lord, in the letter. Lord, the basis on which the price mechanism, the prices were determined in that feedstock agreement, those were not summarized not in the letter which was written as to why there's a difference between one and the other. But the goods which are purchased by my client, the goods which are purchased by the other petitioner. So that was given. Market data was given to show that the price at which I'm buying is the arm's length price. So I established my price, my purchase price, on the basis of other material. I summarized what my agreement was, but I did not. I said that agreement, you can have a look at it online even, or when you visit the site. It has already been looked at by the authority earlier in the earlier investigation, but I did not put a copy of it on record. That's a fact. But I did my best to, because they're looking at that the price should be an arm's length price. If I'm getting a favored treatment, if I'm being favored by the supplier of that ethane, and they're supplying it to me at a lower cost, a lower price, the correct word should be price, lower price, then I have the advantage of having a lower cost of production because of that special arrangement between me and a related person. Whether that supplier is a related person. So I did my best to show that this price which I'm buying it is the arm's length price. It compares with the market price. That I did. Now, none of that is stated. All that they say is you have not given the agreement, but not the other things which were a part of the record. Those have been rejected impliedly, but not where this order does not show consideration of that. So one is that the document itself, and I will place from the letter, the document has already been looked at by them. It is not, because there were previous 2 investigations. They have looked at it, and I put it on record. They are not disputing that position, that the agreement has already been looked at. So this is one part, and I'll show from the correspondence. The other part is not that whether my non-disclosure of the agreement is one part. The other is on what material they say has relied on best information available. So I'm still at a loss because 100 you made 140, 141 without really my knowing how you have traveled to that figure. Because if my cost is altered, it is my cost. If somebody is altering my cost, then on what?
And the basis of you arriving at the cost that you have indicated was provided to them?
Fully.
Was this not one of the bases?
My Lord,
was this feedstock agreement? Feedstock is what it's called. Yes,
Yes.
feedstock supply agreement.
I had given my
Was
purchase
this
price.
not one of the several bases which?
I had given my purchase price because I'm buying, so I had given my entire purchase register. I had given my purchase register, and I had said that please see the purchase register, see my prices. They compare with the market price. So it is not that my figure was unsupported. It is like so. Therefore, none of that is referred to. I am faulted for not showing them the filing the copy of the agreement.
So, according to you, non-supply of this agreement did not hinder their arriving at the anti-dumping price on the basis of the material that you had supplied.
In my humble submission, that is the position, because I cannot say when I know that the authority is going to verify it. I cannot say take my figure and I'm not going to support it. I will not. There's nothing that you need to look at there. I can't say that. So I can. Those are the portions. I will place. Those are actually mostly because they summarize the content of the agreement, so they are redacted in the documents which are annexed. But the pricing mechanism and everything is there. And it is not that I said that you can't look at it. That was not the case. That was not the case at all.
Your methodology of arriving at your conclusions was indicated in whatever.
Totally. Because in the next paragraph, my lord, you will find that they have, because certain costs were regarding the allocation of costs. They said, why is this allocated? Why is that not allocated? So I justified that. I said there are separate profit and loss accounts. Copies were filed. It's all in the correspondence which was there. So why they simply say it was found at variance with the information. But what is the variance? Then that should have been put to me in the disclosure statement that no, you have given this, but this differs from this on this account. So I am actually completely taken aback as to how and it is my figures which are being tinkered with without my knowing what is the foundation. You can reject my figures, substitute it, then what is the material you used? It's elementary, best judgment assessment. The materials used have to be disclosed to me. Dhakeshwari cotton is Supreme Court so many years ago.
When do we meet next?
Monday? No, I won't postpone it.
Tell me. Agreed date, whatever.
9th, my lord. We have agreed.
It just takes advantage of the fact that I will not say anything to.
But the problem is when there is someone above you, we just create
limited.
But we'll again, if it is at 2 p.m., we'll have it again for maybe 1 hour or a little more than that, because then we'll have original sites.
From 3. Or in the morning, even
morning will be, because the only thing is
the other work gets disturbed.
Yes,
it's not a vibe. 2 p.m.
If otherwise we can continue for one day and finish it off, but
Yes,
then
totally.
all the other work will before the vacation. There is a lot of rush.
Yes, it's not fair.
Mr. Katan,
My lords, can I make a mention, my lords? With your permission, my lords.
Are you mentioning with regard to the matter which is ongoing, or
No, a separate matter that I'm.
let the order be passed? Heard Mr. Khetan, learned senior advocate appearing for the petitioner, full stop, for continuation of his arguments, list this matter once again on December 9
at 2 p.m.
2025 at 2 p.m.
I'm grateful.
Very grateful. In both the matters.
I take it back from my learned friend also.
Yes. Yes, sir.
My lords, there is item number 26. It's a reassessment proceedings. 148.
Item.
26, my lords, in today's list.
26 of appellate side or original side?
Original side, my lords. My only request is it can be taken up Monday or Tuesday higher on board because it's been coming on the list, but could not reaching.
Item 26.
Kaushik Roy.
Yes, what has happened in this?
In this, the assessment will get time barred in the month of March. So
March, we
the
are still March.
but
There
my
is time. Please wait. We have matters of December only now.
no, the challenge is I have to obtain a stay from the honorable court. That was the challenge. So if it can be taken on Monday, Tuesday, matters, I'll be really grateful.
Monday, Tuesday, it won't be possible. Please mention on Tuesday. We shall see them.
Grateful, matters. Grateful. Matters.